Our guest today has great experience in alternative dispute resolution, which we'll be referring to as ADR. And she's a woman who is going to give us a lot of information on what ADR is, what happens to women who start off and then they drop off the higher they go, you know, maybe before they become a fella or anything in between. She's going to walk us through that. She's going to also advise us on how to go about it. But first, let's meet her as she tells us a bit about herself as we go into the topic of the day. Phyllis, yes. Elaine Wangwe, that's a beautiful name, and so are you.
Thank you.
Thank you for joining us today on The Nest.
Thank you.
Please say hello to our audience and introduce yourself.
Thank you very much. I'm honored that you're having me here today. Mm-hmm. As you've stated, my name is Phyllis Elaine Machanja Wangwe, and I'm an advocate of the High Court of Kenya.
Yeah.
I'm also an arbitrator. I'm a mediator and conciliator.
Yes.
Yes. And probably maybe I give you a bit of my background, how I got to this place.
Yes, please.
I started out as a banker, and I did my law degree when I was working with a bank.
Yes.
The first time I encountered ADR was in my 4th year.
Mm.
And I was very surprised that something like ADR actually exists.
Yes.
And I wondered, why haven't people taken up this ADR? Mm-hmm. Because for me, with a corporate background, yes, and I don't like war. Mm. Yes, I love peace. Yes, I'm a lawyer, but I love peace.
Yes.
Though we say, huh?
No.
Bila uchaya upanga. You know, like sometimes, even when we want peace, we know there has to be some strife here and there.
Yes.
Some deliberations before eventually sometimes you get to the peace. That is normal in life.
Yes.
But I was very surprised that ADR actually existed, and it was a unit I did in my 4th year, and I picked it up. I picked it up very seriously, but you find by the time I was finishing my law degree, and by the time I was also finishing Kenya School of Law, it had not really taken much shape.
Yes.
Because I trained with Chartered Institute of Arbitrators.
Yes.
And it was an introduction, which was like 2 days.
Yeah, 2 days, yes.
And from there, we needed to do 40 hours for mediation. But it wasn't until 2015 that we actually got quorum and a trainer for us to actually now do mediation.
Yes.
So meanwhile, I did arbitration, which I've also enjoyed along the way. So basically, that is the way I got into this field of ADR. And I left the bank 2014.
Yes.
Hoping to just do ADR totally and nothing else but ADR.
Yes.
But you find that in the space it wasn't well defined. So in practice, so I do civil, criminal matters and all that. But in the law firm, so what we do, I tend to focus on ADR, and other members of staff do the other civil and criminal matters.
Yes.
Yes.
Wow, that is so brave, especially in this particular day and age where women, we are supposed to show up as many things. Without going even into the details, what kept you going from one entire line of work to actually taking a law degree, going to take the post-diploma, which we know it's not easy, and also getting into arbitration and balancing these things? What was that drive that kept you going?
I think going back to school, when I was working in the bank in itself was tough. At some point, I remember asking myself, who said we were going to deduct my salary? Why did I get myself into this mess? Because I remember walking from the college back home. It was cold in Eldoret compared to Bungoma, where I had come from at that time. And it was tough with stiletto shoes, you know. Now it's when I learned how to adjust with time, and I continued. But along the line, I felt like if I have paid this price so far, till the end,
you might as well
I am not giving up on this. The fact that even if it takes 10 years, I will do it. So just the fact that I put in that and I'd already sacrificed so much time, I'd already put in something, made me keep wanting to go on to the very end.
Yes. Great. Very inspiring, because even myself sitting from this end, I've been there, and now I'm doing something completely different. And like we're talking earlier before the show, is that the beauty of such kind of work is you don't need to retire. You can keep going. And there's something about also age and experience, as also we make alternative dispute resolution, something. And I've been hearing it, even courts nowadays encourage it, especially on civil matters, anything that's not criminal that the state has to take up. And you're going to walk us through as to what can be taken to ADR and what cannot. Meanwhile, maybe you could break down to us what ADR is, or what types or kinds of ADR resolutions are.
Okay, there are several. But I'll focus maybe on the major ones from my perspective, because they tend to vary depending on the industry where you are at. But first, ADR is alternate dispute resolution.
Yes.
Which means it's the alternative, and it's actually the alternative of litigation, whereby litigation is going to court.
Yes.
So we have alternative methods through which you can settle disputes. So we first have negotiation, which is which you don't need a neutral party. The two of us, if we have an issue, we can decide. If we have an issue, we can discuss and decide to settle it amicably. Yes. Now, if we don't agree just at that very basic level of negotiation, then we move on to what is called mediation. At the part of mediation, we usually have a neutral party. A mediator is a neutral party and is not does not take sides.
Okay.
And she does not make any decision for the parties. It is the parties to make a decision. What the mediator does is to facilitate.
Okay.
To facilitate them, discuss and reach an amicable settlement.
Yes.
You realize when you have a dispute, sometimes you have a lot of anger and emotions, negative emotions towards each other. But the mediator comes in to cool down those issues and just see that looking at the interests, how can the parties reach a conclusion?
Absolutely.
At that point, it is the parties that actually reach a conclusion, and the mediator can help them draft an agreement, which, if taken to court, depending if it's under the court annex scheme, then it is binding onto the parties. Now that is mediation. And that mediation is usually very good for family matters. Considering that divorce can be very tough. It can be very heartbreaking. So the beauty is that mediation cools it down, particularly when it comes to custody of the children, maybe how to share some of the possessions and all that. So mediation makes it a bit easy. Maybe on that note, just before I go to another one, there is a lady that we were discussing, and I really told her, please, let's do mediation on this one. And I thought we had agreed, but sometimes people want to have their day in court.
True, yeah. And the emotions are running high.
They are running high. I looked at the matter and I thought this was a good matter for mediation. It was to do with the custody of the children or something like that. She insisted she wanted to go to court. And actually, many clients are like, I want my day in court. And if somebody wants their day in court, sometimes there's nothing much you can do. At the end of it all, she was crying and asking me, why did I let her go to court? You see, because you find in mediation, we are very gentle with each other.
It's true.
We are very gentle. The rules of the game are different. But even when I go to court, and I'm representing my client,
you switch up.
The game ball is different. We pull out our daggers because we want to negotiate, to demonstrate that our client is innocent or has the right of way. So you use all means possible that are right and legal to take care of your client. So that is one area sometimes you find mediation is good, but sometimes a client insists because they don't realize what it is like. You know, we were very gentle in mediation, but you seem to think that is the same thing that would happen in court. It didn't happen that way. So now that when you find mediation, you find it in commercial matters, in family matters, and a few disputes here and there. Then the other one is conciliation. Conciliation, you have a neutral third person, but the difference between a conciliator and a mediator is a conciliator has a little more authority and can push a little more and even give suggestions to the parties. And the difference again, you find that a conciliator will write a report which is not expected of a mediator.
Okay.
A conciliator will write a report and even give recommendations. I've sat through some recommendations because I was a gazetted conciliator with the Ministry of Labour.
Yes.
I remember we also had some dispute with the health workers. At the end of it, you actually write a report, their parameters, and that's the difference between conciliation and mediation.
Yes.
Then we have adjudication. Adjudication is a system of means of dealing with disputes, but mainly in the construction industry.
Okay.
Yes, and it's usually pegged at 28 days. Okay. Whereby a dispute has to be arrived at and resolved.
Yes.
Then we have the last one on that. There's made up and expert evaluations, but we'll not get into those ones now. Yes. We have arbitration. Arbitration is a quasi-judge. But as an arbitrator, the rules are not as formal as when you are in court. Yes. The parties get to usually have a say on who the arbitrator is. And many times they'll tend to look at the background of the arbitrator. Yes, yes. Because you find in arbitration, we come from different backgrounds. We have QSs, we have doctors, we have lawyers, we have psychologists. Different people can take up arbitration and even mediation. And like for me, I'm a seasoned banker. So you'll find many times I'll deal with. I mean, when the parties realize that, they'll tend to have me dealing with their solution, with their dispute. So based on that, the clients, the parties will choose the arbitrator. They are sometimes given 3, depending on the institution through which they're getting the arbitrator to choose from. And they'll usually pick somebody who has a background that they're comfortable with. Particularly if it's finance. Absolutely. They want to be comfortable with that without having to take you through the whole process. And now the difference now again with arbitration is that it's confidential. Remember, even mediation is confidential. Arbitration is also confidential. You get to agree on the timings. You get to agree on when it can be done, where it can be done, and how it can be done. We emphasize on party autonomy being one of the benefits of the parties. Sometimes you find parties will want to do it on a Saturday. Then you as an arbitrator, if you're comfortable with that, then it's okay. You see, that's the difference with courts. Yes. And also the police. So that is, those are the basic ones. Basic ADR mechanisms in place.
Wow. It's I'm learning. I remember hearing about them when we were doing this, the basic introduction, but it makes me appreciate how there's so much more than courts, and clearly you can see the differences, especially in comfort, time factor, and probably cost, which you're going to walk us through. But now there's someone at home and they're sitting and they're like, I may not be a lawyer, I may not have had a degree or etc., but this is the path I want to take on either of the ADRs. Now, who qualifies for what? Like, what is the bare minimum to be either of or the five because I've heard you mention you can be a psychologist, you can be, I guess, even maybe a spiritual leader depending on their faith, a banker, or somebody with a background like yours. How does it look for somebody who could be interested in getting in it?
Okay. Different institutions look at different parameters. But right now, we are really moving with the court annexed mediation, whereby basically they want you at least to have done your O-levels. It's preferable if you've also done your degree. But I believe if you've not done a degree, then you have some good experience in a particular area, and it can be demonstrated, I believe, with some certifications. That is the place you begin. Now, with mediation specifically, you ought to have done at least 40 hours of training in mediation. They are recognized institutions by the courts. And even women in ADR, we are getting into that space. And you also have to have gone through mentorship. They have to be sure that you're capable of dealing with the matters adequately, because remember, they are matters of confidentiality. And they don't want the clients to feel like they're being just tossed back and forth. So they want to make sure that those who are accredited as mediators in court have done those specific certifications. So we have several. For me, I did first introduction, which was 2 days. Then I did the 40 hours. But I've gone on and trained further. I've actually also trained as an international trainer of trainers in mediation.
Amazing.
Yes, because for me it gives me satisfaction.
That's it.
Yes.
That's it right there. Because again, I appreciate, because I'm familiar with the legal world, and it's just incredible to know that there are so many ways somebody can, do what they love and what brings them satisfaction.
True.
And again, like you said, experience sometimes is the best teacher. If you're a specialist in a certain industry, then you're better based to do that.
Yes.
I usually see with arbitration, which we can see it's more closer to up there,
court, yes.
Requires a lot of also legal knowledge.
Yeah.
So is it? Yeah, maybe because of reference, looking at maybe contracts and all that. I'm just, standing outside in, but is it a must that you have to, or rather, what would be the advantages? Especially, I know so many lawyers who never ended up practicing. I'm one of them. But of course, I have a lot of knowledge with law. And I think such maybe arbitration, and I choose a certain field, would come easier to me instead of practice. But what's that bare minimum?
For arbitration, at the moment, we have NCIA and Chartered Institute of Arbitrators,
yes,
who are offering courses in arbitration. Arbitration is it's a bit more demanding. It's actually more demanding.
Yes.
Because, for example, let me speak for CIAB, Chartered Institute of Arbitrators, where I'm a member, and I'm an arbitrator with them. You first do the introductory course to become an associate.
Yes.
Then once you've done an associate, then you do another exam. Usually that would be now the following year. Before now you become a member.
Yes.
And then previously there was module 1 and module 2,
yes,
which would also usually take you about a year,
yes,
and another year.
Yes.
So, then you become a member. Then maybe during the 4th year is when you become a fellow.
Yeah.
If we become a
yes,
chartered.
Yes.
But they also have the fast track.
Okay.
Whereby
yes,
you can go and do all those exams in one setting, one session. But few people choose that one.
Yes.
And for the people who would go for that one and it be good with them, I'd usually say are those who are working with arbitrators.
Yes.
You see,
Yes.
if you're exposed to arbitration from the very beginning, maybe as a secretary, you can see you can see what the arbitrator keeps doing. You keep maybe helping them in their research. Then you may be advantaged going for the fast tracking.
Absolutely.
But otherwise, if you've done your law degree, you've gone to law school, it's just good to go through the process.
The process, yes.
Because there's so much you learn with the process, and it stabilizes you. Yes. So there are those options, and yes, is there need for you to be a lawyer? No. We do have quite a number of engineers who are actually arbitrators.
Nice.
And it's actually very interesting. Arbitration in Kenya was actually really started more by engineers before lawyers discovered.
Yes.
And as lawyers, when we discover where we can get money,
we go with it.
We are in.
Yes.
We go to school how to learn.
Yes.
So we got into the arbitration space and we are learning.
Yes.
And I believe we are delivering and also delivering very well.
Absolutely.
So basically, it really, if you have a background in engineering, it's good for you because there are those parameters you look at and all that.
Yeah.
If you're a lawyer, you are also, for me, I think to some extent they say no, but you have an advantage because then you have an idea of what to look out for in a contract.
Exactly.
And when things would go wrong.
Yes.
But when they take you through the training of arbitration, they consider that not all of you have a legal background.
Yes.
And so they take you through the basics. So what you'll need to do is just a lot of studying and be up to speed by the time exams come. Yes.
Okay. Out of curiosity, are there arbitrators, negotiators who just practice that and nothing else on the side?
Yes.
Okay.
We have some who have started out maybe as engineers and their practice has grown.
Yes.
Because of referrals. Yes, because of referrals.
Yes.
Their practice has grown and they're just arbitrators. They're actually chartered arbitrators.
Yes.
I know of some, and then I also know of some mediators who started out as lawyers. They're actually advocates of the High Court.
Yes.
But now they have actually decided to just fashion themselves as mediators. So we have those who have actually taken specific lines. Yes.
It will be injustice if I don't ask this question. Is there money there? Like, we know lawyers really make good money, or the ones we've grown up seeing, but in reality, maybe someone is like, okay, we're doing that, but is there money in the industry?
What I would say personally, Personally, my greatest satisfaction in mediation
Yes.
is not the money.
Yes.
My greatest satisfaction is when I get the parties to settle. You see?
Yes.
So I believe that would be the first thing that you should love peace so much that your joy is seeing these people settle.
I do agree.
So based on that, at the moment, if you go through the court annex, there's a small stipend you can get.
Yes.
It's not that much. And at the beginning, it will not be enough to really take care of your bills.
Yes.
Unless you're very strategic in different ways.
Yes.
But then again, I'd say there's an element of entrepreneurship.
Yes.
It depends on how you brand yourself.
Oh, yes. Oh, yes.
It depends on how you brand yourself and how much you're willing to get out there to get to the public to know that you're a mediator.
Absolutely.
I know there are some mediators who are focusing on training different corporates.
Oh, okay.
I know there are some who are looking for partners to support communities.
Yes.
And so they kind of do it as consultants.
Yes.
So it's really, I was listening to something this morning, and they say if your mind is empty, your stomach will be empty.
It's true.
So it's a matter of using the knowledge that you have to see how you can rightfully get some money from it.
Absolutely.
So saying that there's money or no money, even a lawyer, if you don't go to the law firm, there'll be no money. I mean, you really have to push, have the conveyancing go through to the end before you're paid. Yeah. Push matters until you're paid. So it's the same thing with mediation.
Yes.
And maybe I'd also say, how will you charge and all that? So we don't really have proper scales at the moment. It's something probably that is being looked at. So it's also how you'll negotiate with your clients.
Yes.
Because you may have a matter not connected to court.
Yes.
But once the community realizes or the public realizes you're a good negotiator, and maybe it's dealing with $1 billion shillings.
Very true.
You'll probably tell them, if I'm to do this case and we settle, I'd like a certain amount.
Exactly.
So it's a matter of negotiating. Yes, because now that one you'll be doing in your private capacity. Yes.
Yeah, I think positioning yourself with any industry, it's up to you. That's why I usually maybe like using this example. If you go deep down in a village somewhere, there's a small hospital by a person who studied in University of Nairobi.
True.
But they positioned themselves to be there.
Yes.
And yet there's another doctor in a different city who has a huge practice. And I see how that works.
Yes.
Okay, great. So a lot of mediation or arbitration, there's a way somebody ends up there. And I know some of them, it's because of the court's recommendation. Could you break us that down for us such that you explain how much of that comes in from the court and how much of that, say, a normal mwananchi is in a state of, I'm just looking for somebody who can help us resolve our differences. Like, I know you talked about referrals, but like now today, if you told me go to any arbitration office, I wouldn't know where to start. How does that work?
Okay, when it comes to arbitration, we have NCIA.
Yes.
And Chartered Institute of Arbitrators, whereby they have their members in good standing, and you can decide. I mean, you approach them. Usually, there's a small fee to pay, and they can pick from their members who can settle for you the dispute, depending on the kind of dispute that is there. Actually, if you also go to the Law Society of Kenya, Law Society of Kenya knows the arbitrators and mediators, and will also give some of us the work. So that is that. But again, now what happens is that the ones that go to court, we accredited mediators in good standing are in the database of the court.
Yes.
So when the cases reach there, they screen them, and then they see which ones are suitable for mediation.
For mediation, yes.
So once they find they are suitable for mediation, they usually call us and find out, do you have time?
Yes.
Because the fact that you have time this year does not necessarily mean you'll have time next year.
It's true.
The fact that you have time early this month does not necessarily, or you are not available this month, does not mean you'll not be available next month.
Exactly.
So many times, once they have those cases and they have our contacts, they literally call to find out, are you available to take up a matter?
Yes.
If you confirm you're available, then they'll communicate now formally and send the details to you. Then you'll pick up from there.
Okay.
So there are matters that are suitable for negotiation and mediation, which they screen through and decide. There are those that they find are too complex,
Yes.
this one's better just go before a
Yes,
judge.
yes,
Yes.
absolutely. So we're going to take a short water break, but when we come back, I want you to walk us through the legal perspective where there could be somebody thinking, and I've seen it happening. Sorry to use this case because it's a bit sensitive, but like a case of defilement. You see parents trying to settle and negotiate with a person who defiled their child or ask for money. And in reality, I think that should be a state matter. It's a criminal offense that needs to go to court. So maybe you can break for us down what cannot even be considered, and if that has been happening, and what people should know. All right. Guys, this conversation has just been incredible. I feel like I'm in a class with Phyllis, and honestly, this is really worthy of everything. And if you're at home watching and you're seeing that, my goodness, I didn't know about these things, where do I start? Then this is where you start. So keep watching. We'll be right back.